See if I understand your argument. I understand you to be arguing that a website designer can put anything it wants on a standardized website, even if that includes a denunciation of same-sex marriage. Is that correct?
Yes.
So if, to pick up on Justice Kagan's hypothetical from earlier this morning, if the standard announcement is made with love by Amber, who believes that a valid marriage is a union between one man and one woman, that's okay.
If that's on every website, yes.
I mean, this is, your argument is, you're making kind of a sliver of an argument, right? What is the difference between that and what you think is a violation of your law?
Two things, Justice Alito.
I mean, you're not, that website designer is not going to be serving a same-sex couple if the website designer puts that on the website. They're turning away same-sex couples by doing that, are they not?
They're not turning away same-sex couples. They are defining they are able to choose what services they offer, and that is the service they're choosing to offer. The state does not regulate that at all. All that the state says is whatever you choose to sell.
No, I understand that. Does it make any difference in the real world as a practical matter?
It does in the real world, because my second point is that a website designer like that will lose a lot of opposite-sex couples as potential clients as well, because they don't want to be seen with that message. And what the company wants to do here is take advantage of the public marketplace, of go out and sell their wares to everyone and have control over and change what they sell to different people based on the status of what they have.
Okay, yeah, I understand that. So to sell to everyone. So this goes to the interpretation of your statute, and I'm not quite clear what your position is on it. If a business provides a service that is, quote, open to the public, it's a public accommodation, right?
Yeah, you have to engage in sales or offering services to the public, yes.
Okay. So what does open to the public mean? Does that mean no selectivity whatsoever? Anybody who wants this service can get it, and maybe if there's a greater demand, then the demand exceeds the supply, you've got to wait in line. But if there's any selectivity at all, they're out.
Well, again, it's not presented in this case. The way that Colorado has historically addressed that question is, say, golf clubs who had limited their membership to one gender, did they make money from public coming to their courses? Did you have to be a member to dine in the restaurant, et cetera? So selectivity, as the court discussed in Fulton, certainly is a factor, but it is a fact-specific determination that awaits more facts than we have here, because again,
well, you should understand what your statute means. So if suppose a website designer says, I'm offering my services, but I'm in a lot of demand for my services, and I reserve the right to decide who I will provide a website for and who I will not. Is it a public accommodation then?
If that's the only factor, then yes, but it can make decisions about who to supply that aren't based on protected characteristic and choose its clientele just fine. What it can't do is say, I reserve the right to refuse service, which means in practice, I will not serve black people.